Do you recognize this little guy? That's Mickey Mouse, of course. But that's not just any Mickey Mouse. That is the original Mickey Mouse from the classic 1928 short animated film Steamboat Willie. And as of January 1st, 2024, Steamboat Willie is sailing his adorable little mouse boat into the public domain. What does this mean, you ask? Well, works in the public domain are not protected by intellectual property laws. This means that you or I can use them without getting permission from the owner or paying royalties or anything like that. So does this mean that we can all start printing Steamboat Willie on t-shirts and Stanley cups and whatever other things the youths are into these days and selling them? Well, it's not exactly that simple. And I'm going to tell you why. But first, hi, I'm attorney Aiden Durham with 180 Law Co. in Colorado. Even though I am a lawyer, I am not your lawyer. The stuff I talk about in All Up in Your Business is not a substitute for actual legal advice. If you need help with a legal situation, you should consult with a lawyer. In the US, copyright laws give creators a handful of exclusive rights over their original works of authorship, like literary, dramatic, musical, and other artistic works. This includes the right to copy, distribute, reproduce, perform, or display the work. If we want to use somebody else's work, we have to get their permission, like a license. Otherwise, it's copyright infringement. Or we need to do it in fair use, but that's kind of more complicated and I don't want to talk about that right now. So when we're talking about an animated film or a movie, the film itself is protected by copyrights, as are some of the other elements like the characters in that film. But copyrights don't last forever. They will eventually expire, and like Steamboat Willie and our friend Mickey, they will go into the public domain. They lose the protection of intellectual property laws, and they're free for anyone to use or distribute or reproduce, adapt for commercial or non-commercial purposes. So back to our little mouse friend here. While the copyright for the original Mickey Mouse from Steamboat Willie has expired and it's now in the public domain, not all versions of Mickey are in the public domain. Disney's made a lot of tweaks to Mickey over the years, and pretty much all of those later or more current versions of Mickey are still protected by copyright law. And there's another twist to this story. Copyright isn't the only form of protection for characters like Mickey Mouse. There's also trademark law at play here. And Disney, being as savvy as they are, or I guess their lawyers being as savvy as they are still going to use trademark law to protect their rights in Mickey as much as possible. Like I said, copyrights protect artistic works. Trademarks, on the other hand, protect words, phrases, designs, and symbols that are used to identify the source of a product or a service. So what Disney did is they started incorporating Steamboat Willie into their branding, into their logo. And now there's this little animated clip of Steamboat Willie that shows in the beginning of most, if not all, Disney films. Unlike copyrights, which will expire eventually, trademarks can last forever as long as they continue to be used in commerce. Trademarks don't expire. I mean, they can, but as long as they're still being used, they won't expire. So this means while you could theoretically use that original Steamboat Willie version of Mickey, you can't use it in a way that might confuse people into thinking that your products or your services are somehow associated with Disney. Before I continue, if you're finding all this talk about copyrights and trademarks interesting, or if it's getting a bit overwhelming and confusing for you, I think I've got something that can help. I put together a free guide with the basics of trademarks and how you can use them and protect them for your business. It's perfect for anyone who wants to understand more about protecting your business and your brand. You can click the link down in the description to get that free guide. It's completely free, it's packed with a lot of valuable information, and I promise it's going to make your life a bit easier. So let's break it down a little bit more. What can we do with Steamboat Willie now that it's in the public domain? You can copy the original Steamboat Willie film. You can share it. You can, put up the entire film on your own YouTube channel. You can reproduce it, distribute it, pretty much however you'd like. well, pretty much however you'd like. You can even build upon it and use it to create new artistic or creative work. As long as it's that original version we're talking about, you're pretty much in the clear from a copyright perspective. From a trademark perspective though, it's gonna be a little dicier. More on that in just a second. But what can't we do? What shouldn't we do, even though Steamboat Willie is now in the public domain? Well, you can't use any of the newer versions of Mickey Mouse. Those are still protected by copyrights. So even though one version of Mickey is fair game, don't think that you can start using like the Mickey Mouse from Fantasia or Mickey's Christmas Carol. Again, still protected by copyrights. And remember, copyrights and trademarks are two very different things. Because of Disney's trademark protection, you still can't use Mickey, even that original Steamboat Willie version of Mickey, in any way that might cause consumers to think that your products or your services are somehow associated with or coming from Disney. Because Disney is such a well-known and famous brand, they get to benefit from this other concept called trademark dilution. Trademark dilution basically refers to unauthorized use of a trademark that might weaken or diminish the public's perception of a famous brand. Etsy and a lot of other online retailers are currently flooded with products including the original Steamboat Willie character. But if Disney decides that that somehow dilutes its trademark rights, then they may start relying on trademark law to crack down on a lot of those products and the people who are selling them. So if you're thinking of starting a business like selling Mickey Mouse t-shirts, you're going to need to be very careful that you are not infringing on Disney's trademarks when you do so. Remember, when it comes to intellectual property, it's always best to err on the side of caution. And when in doubt, please talk to a lawyer. So while Mickey Mouse's entrance into the public domain is really kind of a landmark event, it doesn't mean that it's now a free-for-all for Mickey and for all of us to start using Mickey however we want. As with many things in the law and in business, it's complicated, of course. That's all for now, folks. If you learned a thing or two, smash that like button and make sure you subscribe so I can stay all up in your business, and sometimes you can get all up in mine. If this video got you thinking about copyrights and trademarks, then I have another one that you might be interested in. You can check it out right here, and I will meet you over there. Thanks so much for watching. I'm Aiden Durham, and I'll see you next time.